Good morning, Ms. Lathan. Thank you, Mom, for coming. Appreciate it. Ms. Lathan, you're charged with assault of a...
This is what's called a probable cause hearing. It doesn't decide guilt or innocence only if there's enough evidence to move forward. But notice how even at this stage, emotions and family drama can weigh heavily on the case. Quick question. For you, do you think family disputes should even reach this level of court?
family member, you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you. Okay.
Judge, the complainant reported being assaulted by the defendant, who is the complainant's daughter-in-law, at the defendant's residence in Harris County, Texas. The complainant stated she was at the residence with the defendant for the complainant's son's birthday. The complainant advised she engaged in a verbal altercation with the defendant about the child not saying goodbye. The defendant got into the victim's face and the defendant lunged at the complainant as if the defendant was going to strike her. The complainant stated her son and husband attempted to separate the defendant and the complainant, but the defendant was able to kick the complainant's right breast, causing a high level of pain due to recent breast cancer surgery. The complainant stated the defendant yelled, quote, "I will fuck you up," as she was pulled away. The defendant stated they had a get-together for the defendant's husband. The complainant became upset during that conversation, and the complainant was slamming doors, yelling and getting in the complainant's face, but did not kick the complainant as she was 9 months pregnant. The defendant was identified with a Texas driver's license.
I make a statement, Judge. And so this case was it 6 months later that it was filed? They never spoke to any of the witness. Janitha was present at that time. Terrell, who's a bailiff upstairs, was present at that time, which is Jillian.
Well, this is a critical defense point. The argument is that the complainant physically couldn't have been kicked the way she claims because of recent surgery. Add to that a witness who says she was 9 months pregnant and suddenly the story has two very different sides. Who do you believe here, the complainant or the defendant's witnesses?
Husband, he didn't want to go through the whole IED deal and give a statement just yet. But I did provide a witness statement from Janitha where she was there. She was 9 months pregnant at the time, Judge. She had her baby a week later. Her mother-in-law did have breast surgery, cancer surgery before on her breast, but she couldn't lift her leg up 3 inches, much less high enough to kick her in the breast. The police officer had none of the information with regards to Janitha being present. Janitha was there. There was the mother and the Terrell and the father holding the two back, I guess, from each other like this. It was split up, and then that was it. 6 months later, charges were filed against Miss Lathan, and that's it. Officers never spoke with anyone, didn't get the other side of the statement. Janitha did provide a witness statement. The court can ask Janitha. We're open to the court asking the questions to Ms. Kimbrough. She didn't witness anything after it was split up. They went home, I guess, Janitha, and then that was it. There was no physical contact, anything of that nature. Nothing.
Give a response, Mike.
Judge, I haven't read the offense report thus far. I know that this is what the victim has reported. I don't know who the investigator spoke to, but I know this was a delayed report. That's why the 2B warrant was filed.
There was no documented injuries, Judge, no photographs, no nothing. They just on their own volition.
Remember, this is just mere probable cause, right? So, and the fact that, she's pregnant is unable to, I don't know that, right? So all this is a probable cause. It doesn't mean that you're guilty, right? Just it's a mere probable cause. There's still a lot before someone can be found guilty beyond a reasonable doubt. I mean, that's a lot higher standard than what we're just doing today. I am going to find that there's probable cause to go forward. What's the dynamic now? I guess it's 6 months down the road.
I mean, they all
do they want to have contact?
They all. Do you still have contact with your mother-in-law?
So on Marilyn, is there still contact between you guys?
On and off, not too much.
Okay, so the only thing I'm going to ask is just don't have any threatening or harassing contact with this person. That's all I'm going to ask you to do at this point, okay? I'm not going to put any other conditions in your bond. Just be careful. Don't pick up any new cases. You got a great lawyer. I will waive your appearance. You don't have to waste your time coming to court. Mr. Kamek will tell you when you have to come back to court, and that's all there is to it. Just be nice. Don't pick up any new cases, You guys have any questions?
That's it.
So for now, what I'm gonna do is I'm gonna have just Michael create the bond conditions, we'll have you sign it, and then you guys are free to go. Just do your thing, and just have fun.
Judge, did you set a bond amount?
Oh, Mr. Torres, you're charged with assault of a family member. You are facing a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On October 15th, 2024, officers dispatched to a welfare check at a residence in Harris County, Texas. Officers made contact with the complainant, who was observed to have a fresh, large bump to the back of her head. The complainant was observed to be very scared to speak to law enforcement at the time of their arrival, while the defendant was in the area. The complainant insisted that she wanted to leave the house and get out. The officers made contact with the defendant, who stated that him and the complainant had been dating for about 1 month and had recently had a couple verbal arguments. The defendant stated that he was outside and heard screams coming from inside, and when he came inside, he found the complainant on the floor in the living room and that she had fell from the stepping stool that was in the living room. The defendant stated that the argument never got physical between them, and the officer contacted the witness, who called in the welfare check and stated that he received a message from the complainant of a picture of a firearm. The witness stated that the complainant began sending him audio through WhatsApp, and on the audio, you can hear the complainant say, "Jose, run. He is going over there with a firearm, run now." The second audio that was sent from the witness, you could hear the complainant telling him, "I was able to take the firearm away from him, but he had a knife, run." The witness stated he called the complainant and was able to hear a disturbance between the complainant and a male. The complainant tells the witness, "I don't want to die," and the witness then overhears a male yell, "If you call the police, it will get worse." And then that's when the witness heard them arguing, and he can tell the defendant's mouth was then covered and can no longer talk. And then the complainant stated the defendant was upset that her ex-boyfriend was trying to pick her up, so the defendant placed a firearm inside his waist and said he was going to look for her ex-boyfriend, and he left the house. The complainant stated the defendant returned a short period later and continued to argue with her about leaving the house. And
there it is, probable cause found again. Notice the immediate protective order: no weapons, no contact, strict rules. Judges take these conditions very seriously. If violated, it's straight back to jail. What do you think should courts issue? These protections automatically in domestic violence cases, or should it depend on the evidence?
When the complainant was exiting the master bedroom and going towards the living room to leave, the defendant pushed her back, causing the complainant to fall to the ground and hitting her head with the floor. The complainant stated she lost consciousness after she fell, but when she woke back up, she was already laying on the bed when the defendant was there pleading that he was sorry and he didn't mean to hurt her. The complainant stated she did feel pain. And that's it, Your Honor.
So it is the pushing and falling on the floor and getting hurt that way. Okay. Mr. Torres, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. Do you understand? You don't understand?
No, not one time.
He said, no, he's not going to have contact.
Okay. I'm also ordering you not to be in possession of any weapons. No guns. Do you understand?
Yes, sir.
If I find that you have a weapon, if I find that you try to have contact with this person, I'm going to put you in jail and you will not get any more PR bonds. Tell me, are you a United States citizen?
Yes, sir.
You are? I'm entering in what's called a magistrate's order for emergency protection. This is a court order that identifies Yolis Hernandez as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand? If you violate this court order, the state can and will file an additional charge against you, violation of a protective order, and then it's really bad. Do you understand?
Yes, sir.
If you ever have any questions, Mark can help you and guide you through this. Because you have a lawyer, I will waive your appearance so you don't have to waste your time coming to court, but you must stay in touch with Mr. Metzen. He will tell you if and when you have to come back to court. If he tells me he can't get a hold of you because you're playing games, I will issue a warrant for your arrest. So don't pick up any new cases, no contact and no weapons. That's it. Do you have any questions? Okay. As far as the bond is concerned, we need to take care of that.
Yes.
Do you have any prior criminal history that you guys see? Alex?
I can run his NCIC.
In Texas, no, Your Honor. I don't know. Outside, I doubt anything outside.
Your Honor, I don't see any other criminal history.
Mr. Torres, I'll set your bond at $500 and I will give you a PR bond today. Okay, but I will not give you another PR bond. If you pick up a new case or violate these conditions, I'm going to take that PR bond in a moment's notice. You understand? Okay, my friend. So take a seat. We'll have you sign all the documents. Don't leave until we let you go. Okay? All right.